Good morning, everybody. This is Howard Seidel, Senior Partner at Essex Partners. And on behalf of all of Essex Partners, welcome to this morning's webinar. Thank you for attending. It's almost impossible to overstate the impact that COVID-19 has had globally, but in the US, certainly in our everyday experience on social and economic matters, and subsequently its impact on legal issues, and particularly today we're going to focus on as it relates to employment issues. So with that as context, I'm very pleased to introduce three outstanding attorneys from Sherin and Lodgen Employment Department to discuss those legal implications. Brian MacDonough is the chair of the firm's employment department, expert in a wide range of employment matters and executive advocacy. He litigates cases in both federal and state courts and is represented before state and federal agencies. He's ranked by Chambers USA for his labor and employment practice. David Brody is a partner in the employment department on a range of employment matters. He's an experienced employment litigator representing clients in state and in federal court, as well as in public hearings. He's a member of the Bar Association's the Boston Bar Association's Labor and Employment Steering Committee. And Nancy Shilepsky is a partner and former chair of the employment department. Nancy, who I've known for a long time, is nationally recognized for her work in executive advocacy and employment law and employment litigation. She's been a pioneer in wrongful termination and employment discrimination cases. Her accolades include Chambers USA's highest rating, star individual ranking, repeat listing in Thomson Reuters Boston Magazine as one of the top 10 Massachusetts super lawyers, and she's on Law Dragon's 500 list of leading lawyers in America. During the session, please ask any questions you have. Use the chat feature to put those into the system, and then there'll be time at the end of the session also for Q&A. With that, it is my pleasure to turn it over to Brian to start the panel and the webinar.
Great. Thank you, Howard, and good morning, everybody out there. Before we kind of jump in, as Howard mentioned, I would certainly encourage, I'd like to make it as interactive as possible. I mean, I know there are limitations through a webinar. But we're a relatively small group this morning, and I would certainly welcome questions along the way, as well as, I mean, we did set some time out at the end, but feel free to ping us along the presentation. So we've kind of broken this session today into 3 sessions, and I'm going to start out and set the plate a little bit, so to speak. I'm going to start by talking about executives and professionals that are getting ready to make a move or a transition during COVID. If we could put the first, thank you. So anytime an executive's thinking about making a move, it's incredibly stressful, uncertainty. You mix in a global pandemic and then the current economic climate, it just heightens all those concerns and sensitivities. One of the first real factors is obviously time consideration and protecting your compensation. Even in cases where you believe there's no dispute as to what the executive has earned, what the executive is entitled to. These are things you really just, when you can, now every situation is different, you want to manage the calendar. If that, that bonus is being paid in February, feel a lot more comfortable that hitting my bank account before making a move. At a practical level, if there's ever a dispute, it's always going to be a lot easier for the company to make a non-payment or to turn off the spigot as opposed to clawing something back. So this would apply to annual bonuses, long-term, short-term incentive payments, vesting regarding equity. If you're thinking about making a move and you're just looking ahead and, hey, there's another significant vesting cliff, that is obviously going to influence the timing of the decision when to jump or not to jump. Another significant issue is being mindful of notice requirements. Now, this could be, as simple as in the offer letter, you're required to give, 2 weeks, 30 days notice, whatever the case might be. I think it's twofold. One, you want to understand what requirements, if any, there are as far as the time period that has to be given. And also if there's any procedures. Sometimes you will see some pretty archaic notice provisions that, notice has to be given in a certain manner. You may see, certified mail, return receipt requested, and that you have to copy folks that you wouldn't necessarily think about, whether it's a chairperson here or a council or whatever the case might be. You just want to make sure you check all the boxes so that nothing can come back on a technicality that you failed to provide sufficient notice as contractually required. This becomes particularly important when we're talking about a good reason trigger. If an executive is in the position to, under their agreement, oftentimes on one side of the coin is, company letting somebody go without cause. What happens there? Hopefully, if you've negotiated a good deal on your way in, you have the other side of the coin, which is the executive's ability to raise their hand and say, hey, I'm out of here for good reason. And that, the most typical good reason process is, anywhere from executive has to raise his hand within 30 or 60 or 90 days of the occurrence of the good reason. The specific language can vary, by contract, but that's kind of the rule of thumb that you see. The most common good reason triggers are, relocation, material breach, material diminution of duties, responsibilities, and authority in the role. Sometimes significant cuts in compensation. Oftentimes it's with the caveat, unless it's an across the board cut, which is something we've been seeing a lot of in COVID. Many companies are tightening up and asking their senior leadership to take the lead on that. So depending on the specific language in the contract, certainly during COVID, executives that are asked to take a haircut might not necessarily rise to the level of good reason. But it's also important, often as part of the good reason process, it's, you give the notice, you might have to specify the specific reasons, and then there's the cure period. The company has the ability to cure. So oftentimes what happens if there's a dispute, whether the company takes the position there is no good reason, and or the company takes the position that we've cured good reason. Oftentimes an executive is in a position, one, that may lead to a negotiation. If there's a dispute as to whether good reason exists or not, it could very well lead to a negotiation, and the separation may still occur, but it just might be on different terms than otherwise provided in the agreement, or at least called something different. The other is oftentimes executives are, if they're wanting to protect their contractually owed severance, say, they may have to actually terminate, because it's, that the process is you give good reason notice, there's the cure window. More times than not, you'll see language that executive may have to actually terminate, right? So, and there might be, again, a time period on that, within 30 days of the end of the cure period. So you just want to make sure you're checking all the boxes, both as to time, notice, and those requirements. Another kind of major, before you jump, look is getting your head around restrictive covenants. It is, I probably see this more, this is probably one of the most common issues we see, and executives oftentimes struggling with, is getting their head around the full scope of the restrictive covenants. I'd say two common issues is, one, the misperception out there that say, and by restrictive covenants, I mean non-competes, non-solicits, non-ratings. Two very common issues I see with executives that we work with is, at the beginning, a misunderstanding, the view that, well, this thing is this is not going to be enforceable. They let me go. They let me go without cause, say. They can't prevent me from earning a living. It's not uncommon. It's, pick your industry. Look, I've been a healthcare administrator for 20 plus years. How can they prevent me from earning a living? This is, no way is this thing going to be enforceable. And the other issue I see is executives, there's oftentimes more than one restrictive covenant. You know, you may have a non-compete in your offer letter or executive employment agreement, but more times than not, there are other, you know, whether it's a non-compete or a non-solicit, tied to your equity awards. And this is sometimes overlooked. It might be spelled out in black and white in the award agreement. It might be spelled out in black and white in the underlying plan document governing your equity. And oftentimes these restrictions don't necessarily mirror what's in your employment agreement or what's in a standalone. So you need to gather all the information, see how these pieces work together. One really hot topic that I've been seeing, you know, particularly during COVID, is the issue about, you know, how courts are, you know, going to deal with enforceability, you know, regarding non-competes. A little bit of background, just, you know, to set the stage a little bit, you know, standards vary and can vary greatly from state to state, you know. So that's one, just, you know, one, you have to understand, you know, what the playing rules are, and recognizing that it varies and can vary greatly from jurisdiction to jurisdiction. But generally speaking, you know, non-competes will be enforceable to the extent it is reasonably necessary to protect a legitimate business interests. And this is factoring in duration, you know, the time, you know, 12 months, 24 months, whatever the case might be. And also scope, you know, are we talking geography, worldwide, you know, within the United States, within a specific territory, or, you know, also too within a specific industry. Like I gave the example, you know, the healthcare administrator. Well, you know, is the company that he's come from, is that, you know, all healthcare? Is it, you know, say the company focused on behavioral health? Is that the scope, or can it be, you know, can it go beyond that? So there's, of course, this tension between, you know, an executive being able to earn a living and a company being able to protect their legitimate interests. And much to the chagrin of many of the executives we work with, folks want black and white answers. This is enforceable. This is not enforceable. Like they want the black or white answer. The reality is, when we're in non-compete world, yes, there are certain things that are black and white, but there's just a whole heck of a lot of gray. And the reality is that's where these disputes arises in when we're dealing with the gray. So these cases are any dispute, it's very fact specific. One thing, now there's not, I mean, in part because it does take some time for cases to work through the legal system. So as we sit here today, it's not so much, you know, we can report data and trends as far, you know, hard specific objective data about how courts are handling these, but there is, you know, a lot of legal observers and commentaries, and I'll throw the three of us in that group, is, you know, I think certainly in jurisdictions that are more employee friendly in the non-compete world, and certainly Massachusetts is in that category. I think when you look at the dynamics that we're currently dealing with in COVID, we're dealing with historically high unemployment rates, amongst other challenges for professionals. You know, I suspect we will be seeing some more employee-friendly rulings on the close calls, you know, on the cases that, you know, for public policy reasons and otherwise, I think we will continue to see a trend of more, you know, employee-friendly in this world. One little backdrop, and I know David's going to speak to this in more detail, so I won't go into it too much right now, but in 2018, Massachusetts implemented significant non-compete reform. It was many years in the making. The one thing I'm just going to flag now is a date. It's an important date to remember. And that date is the new law went into effect October 1, 2018. So certainly if for executives who are, you know, looking to see, you know, their rights, what is enforceable, unenforceable, that's one place that you definitely want to see. Is this pre or post October 2018? Now, even in older agreements prior to October of 18, you know, they are grandfathered in, so to speak, but that does not mean that there may not be a valid basis to challenge the enforceability. But I'll leave that as now as the kind of, the date is the line in the sand. You certainly want to be mindful of, you know, when these agreements were entered into. You know, if this is something, you know, employment began 6 years ago, you know, you might very well, and there could be a scenario where you have some covenants govern under pre-2018 law, but this might be something on an annual basis. When you get your award, you know, you may have some under current law. Another thing just to touch upon, fiduciary obligations. You know, these become, you know, important when an executive is planning on making a move. Now, separate and apart from any standalone confidentiality agreement or restrict, you know, non-compete, non-solicit, executives and professionals have certain common law fiduciary obligations to their employer. Much of this is common sense. You know, you can't steal the client list or the secret formula on your way out. You can't run, you know, a competing business on the side while you're still employed there. You know, that's the kind of, you know, use good common sense. You know, confidentiality agreement or not, you can't be, you know, trade secrets, you can't be stealing trade secrets. Now, but one thing I want to flag and keep in mind, and, you know, the case law is developed, it is clear in this respect that planning to compete versus, you know, unlawful competition are not the same things. And planning to compete does not run afoul of fiduciary obligations. Now, what planning to compete means, what that line is, as far as what's acceptable, what's not acceptable, you know, that's probably a webinar onto itself, and certainly much more than an hour. So can't go into that, but I just certainly wanted to flag the concept. Some of, you know, just to give a couple of examples, you know, somebody who's planning on making a move, setting up assuming it's otherwise permissible conduct, setting up a competing business. There's nothing planning to compete in the sense of, I hired a web designer to put a website together so that when I open my doors for my new business, I can hit the ground running. I would certainly argue there's nothing unlawful about that. I wouldn't launch the website and have it live to the world while you're still employed, but kind of that is a sense of planning to compete that's permissible. Lining up office space, you know, that you need to, you know, get a lease ready to go, to have space so that, you know, when the doors open on Monday, you're ready to go. That I would put in more the category of planning to compete, which is permissible conduct. Obviously, and I just want to kind of, a lot of these points are looking at, okay, here's my existing employment arrangements. The last point on this slide I certainly want to talk, it's the choreography. These things, you know, when you provide notice, in large part is dictated, you know, where do things stand with negotiations with the new employer. In a perfect world, this is, you know, you've negotiated with the new employer where you're going, the agreements have been finalized and signed, and then you're pulling the trigger almost simultaneously. Frankly, I prefer to choreograph it that closely, that the new deal is firm, it's done, it's ready to go before giving notice. I've just seen it and see it too many times. Things go sideways. Giving notice prematurely and then having the deal fall apart. That, you know, you do not want to be in that position. Now, that's like in a perfect world that you can choreograph it. That is not always the case, but that is certainly the problem. You don't want to pull the notice trigger too early. One recent COVID horror story that I'm just going to share quickly. Now, this was early in COVID, very early in COVID. And this was a client that we worked with who did everything right. This was a client who, long-term, you know, executive at an organization, 20 plus years, was planning on making a move, did everything right as far as, honoring her obligations to her existing employer, negotiating a deal with the new employer, did this choreography giving notice. That was probably in early February. Was going to take a nice 3-week break down in the Caribbean somewhere and come back and start work, mid-March. And then COVID hit. Now, the new employer, retracted on the deal. Initially, they said, look, we're just going to push back your start date, because of everything that's going on. And then it became, we're not in a position to honor this. Now, this was a horrible position for the client to be in. And the reality is, there's obviously protections that can put in contracts to protect an executive. Nothing is 100% foolproof. This was a situation, that thankfully had a happy ending in the sense that the executive was able to go back, had left on good terms, was a good leaver at the old place, was able actually to go back there and continue. It was a situation. Now, were there potential legal arguments that the new employer breached? Yes. Can arguments be made, based upon how the contract is written, that the new employer had an obligation to bring that person in? Yes. Or, other arguments can be made, but you don't necessarily want to be in that position if you don't have to. Now, certainly from a belts and suspenders, I rather see an employment agreement says there's a contract effective date X saying we are going to employ you starting on day Y, as opposed to a contract that says this will govern your employment, if you start on day Y, right? Which it's not always, there's some nuance in that, but there are things that can be due in the contract. So this is actually going to move me, if we can put up the next slide. This is more, now I'm facing towards, the executive is yet to make the jump officially, but they're negotiating with the new folks. This is what I call the honeymoon phase. It's negotiating the in deal, but also preparing for the worst. What's COVID this year? What's going to be the next the issue that we're going to be dealing with? A couple of things I would just urge executives out there, things that I see. Now, this might be easier said than any negotiation is all about leverage. Now, COVID may hamper some of that leverage. If this is a situation where it's more of I need a job, I don't have a lot of leverage, to negotiate the terms, in large part given the economic climate, that might be the circumstances. But if you're in a position where you do have some leverage, now's the time to exert it. And sometimes I see executives who are hesitant to rock the boat on the way in. I think there's a middle ground there. This is a point in time, most times, where you can have frank, good faith negotiations looking for the win-wins, as opposed to a tail end where people have swords drawn at each other's throats. So I do encourage executives not to just say, I don't want to rock the boat, but to consider, certain protections on their in deal. The basics is, contracts 101, the four corners of the agreement. If it's not in the agreement, the four corners of the agreement, it's not part of the deal. So certainly all material terms, anything of value, significant value, needs to be referenced in the agreement. If there's discussion, oh yeah, we do this, we do that, anything of material importance or certainly financial value should be spelled out, referenced in the agreement. Now the basics, obviously, the term of the agreement, is this rolling year to year, at will for a specific term, title, reporting. Reporting relationships can be really important because that can come into play, with a good reason situation. If it's clear that you're going to be reporting directly to the CEO, and then down the road you get layered. You might hold the title, but you're no longer on this, reporting directly to the CEO. That could very well be a good reason trigger. Things like base, bonus compensation, equity. It should all be spelled out in the agreement, what the severance amounts are. Now, I'm just going to flag, Nancy's going to touch upon this a little bit in how the CARES Act may impact some of these discussions as far as, the level of compensation kind of going both directions, as we'll see. The other piece, the protections. This is where, the devil's in the details, the definition of cause. Now I put in, you see here, that's a capital C, not a lowercase c. You never want to be in a position where you're dealing with a lowercase c, the common law definition of cause. Executive, part of the goal here is to negotiate as most protective language you can around things like cause. Now that might include, cure provisions that, if there's assertions of cause that you have an opportunity to cure that. That might include language about trying to make it as a higher standard or more objective standard as opposed to a subjective standard. We talked a little bit about good reason. If you're in a position to do so, you want to negotiate the specifics around that in the process. Oftentimes when we're talking about severance payouts, not oftentimes, I'd say 90% of the time it'll spell out there, hey, you're gonna have to sign a release of claims. And a lot of times you see in a form acceptable to the company. Now what I'd like to take the approach, what the heck does that mean? I'd rather not have a fight down the road when somebody puts a 20-page separation agreement in front of you and then you're trying to negotiate there. I'd rather see it negotiate up front, and reference it and attach the template to the employment agreement. Some heightened issues that I've seen during COVID that sometimes become just, non-factors historically, issues around working remotely and travel. These are becoming huge issues. If there are unique situations that need to be addressed, it should be spelled out in the agreement. Disability accommodation issues. Executives often have, one of the triggers for termination will be, in the event of your disability. This kind of takes on some heightened significance in a COVID world. Well, what is the definition of disability? Are we modeling it under, state and federal law? Or is it some other standard that, the company gets to pick their own physician? So these are issues that I've seen taking on more significance during COVID, and certainly tax issues. Nancy will touch upon it a little bit in the CARES Act, but there might be significant issues arising under 409A. So if we can move to the next slide. So when I started talking about, making a move, sometimes there's a position, sometimes it's, I need to get out of town, I need to get out of town yesterday. Other situations there might be in a, whether it's looking for a win-win or a good leaver situation to, to stick around and assist. It usually comes in twofold. One, there just might be, as part of the separation, very clear transition cooperation services, or, that the executive is offering to provide. You should just be clear as to the scope and duration as that. One key thing I would flag in doing for consulting arrangements is a 409A tax issue. And you want to make clear that there is what's known as a separation from service. The nutshell is there can be significant tax penalties under 409A, if it's not properly followed. The measuring stick for separation for service, to be safe, is if the executive is going to continue to provide services, you would want it spelled out at what level. And frankly, the safest is to be at 20% or less of what was done previously. So there are circumstances that can sometimes go up to 50%, but you never want to just on paper say, consulting, but in fact, continuing to work full time. There could be significant tax implications there with, for example, in addition to all taxes, there might be owed a 20% penalty and it falls on the executive's head. So if we can, so I know I covered a lot of ground, But with that, I'm going to kind of transition over to Nancy in the CARES Act and what we might be seeing next. So.
Thank you, Brian. Good morning. As probably most of you know, the CARES Act was signed into law in March of 2020, and it provides, among other things, access for loans and loan guarantees from the United States Treasury. And there are, unfortunately, strings attached to those loans and loan guarantees, which may impact executive compensation. So today I'm going to talk about two of the CARES Act's programs that include those strings and how those strings do impact executive comp. Next slide, please. The first program I'm going to talk about is the PPP. This is a smaller program, less money in it, but it does have an impact. The PPP provides forgivable loans, right? They're loans, but they're forgivable, depending upon how the loan money is used. It's supposed to be used for things such as rent and mortgage and payroll, and forgiveness depends upon the circumstances under which such loans may be forgiven. So just right off the bat, PPP loan money can be used for salary, but it is capped. The amount that can be used, PPP money, for any one employee is capped at the annualized equivalent of 100,000, right? So it's easier to use more of it for lower paid workers. Now the 100,000, let me just be clear. What is not in that cap. And remember, it's not 100,000, it's the annualized equivalent of 100,000. So what is not included is paid leave, vacation time, sick time, separation pay, payment of insurance premiums, retirement contributions. None of those are included in the cap. Next slide, please. In addition to limiting how the funds may be used, the PPA loans are forgiven only if they're tied to certain conduct on behalf of the employer. So, for example, there are requirements that the employer maintain headcount, either by retention or the timely rehire of furloughed employees. There's also a requirement limiting how much the wages of employees can be reduced. But that protection is only available for employees who've earned 100,000 or less in 2019, right? So if you've earned 90,000 in 2019, if your employer wants forgiveness, they cannot reduce your compensation by more than 25%. On the other hand, if you earned 300,000 in 2019, there's no cap on how much your compensation can be reduced without putting the employer at risk of losing the forgiveness. So, intentionally or not, the PPP loan program incentivizes the reduction in compensation of higher paid executives, and possibly even the elimination of the employment of higher paid executives. Now, the good news is that in June, the PPP program was amended. So the borrowers, the employers, now have 24 weeks rather than 8 weeks to use the PPP loan money for the forgivable expenses. That takes some of the pressure off. Next slide, please. All right, far more relevant. Let me, hold on one second, folks. All right. I don't know if people have heard about CESA. You've probably heard about the Main Street Lending Program, which is under CESA. CESA's under CARES. This is another loan or loan guarantee program. These loans are not forgivable, right? That's not an issue with the CESA loans. The issue is that they're loan and loan guarantees for mostly up to 5 years, mostly on favorable terms. And they are usually, there's some overlap of availability of PPP loans and CESA loans, but the CESA loans are intended for more the mid-size and larger employers. The problem with these is that there is a restriction period, and that period runs the time of the loan plus a year, at least a year thereafter, right? So say your employer, your prospective employer, gets a 3-year CESA loan. The restrictions about which we are going to talk is a 4-year restriction. So what are those compensation restrictions? I'm going to go through them one by one. During any consecutive 12-month period, right, while the loan is active and at least 1 year thereafter, executives who receive total compensation between $425 and $3 million in 2019 may not receive more than what they received in 2019. Their compensation is capped. So if in 2019 you received $430,000, that is capped. That's your cap for the next, using my analogy, 4 years. 3 years of the loan and 1 year thereafter, at least 1 year thereafter. That is your cap for 4 years. If during 2019 you received more than $3 million, you actually get a haircut. The haircut is you can receive $3 million plus 50% of the excess. So say you received $4 million in 2019, during the restricted period, you can receive in any one 12-month period, you can receive $3 million plus half of the excess, which is half of $1 million, so $3.5 million. You actually get a haircut. Affected executives also, in terms of severance or termination benefits, can't receive in excess of twice the total amount received in 2019. Next slide, please. So since a lot of the Essex folks are executives in transition or have been in transition, some of what is on this slide is going to be relevant to you. These things were not clear originally, but they've been clarified. So what happens to an executive who began employment during 2019 or thereafter? Right, so you didn't get a full year in 2019, or you get, the way it sounded was you'd be capped at, whatever, if you started July 1, you'd be capped at half a year. That's not how it works. The reference period regarding from which the cap is determined is not calendar year 2019. It's counted from the end of the month in which the employment began. So if you began in June of 2019, your reference period effectively starts July 1, 2019 through June 2020. So what you earned in that period is what the cap is determined on. Now, using that example, your cap period is over, your reference period is over. If, however, you started employment on October 15th, your reference period will run from November 1, 2019 through the end of October 2020. So you're still in that period that from which your cap is determined. So, you know, if you're earning 430 during that period and you don't want to cap, maybe you ask the employer, you negotiate to get more into the reference period so your cap is not so low going forward. On the other hand, if you're coming in just under the cap or just close to the cap, you may want to say, no, hold that money back so I'm not capped for the next 12 months. So those are the sorts of things that you're going to have to look at and think about if your employment began during 2019 or thereafter. So what about executives whose compensation first exceeds the 425 or the 3 million during a consecutive 12-month period ending after 2019? Again, your reference period is not calendar year 2019. Your reference period is counted from the end of the month in which your compensation first reached that cap, right? So you still have time, you know, to sort of work this out so you get a higher cap, or you stay away from the cap entirely. Next slide, please. All right, what do the caps apply to? Caps apply to a total compensation. So how is total compensation defined? It includes the obvious things: your salary, your bonuses, your awards of stock and other financial benefits. What is as yet unresolved is how unvested compensation is going to be counted. So most likely, if you get deferred compensation, but it's vested deferred compensation, that is likely to be counted. If, however, it is unvested deferred compensation or unvested equity, that likely is not counted in determining the cap. All right, additional requirements. Mid-sized employers have to make a commitment to make commercially reasonable efforts to maintain payroll and retain employees, et cetera. I think in the long run, that's likely not to be particularly enforceable. Next slide, please. All right, so what does this mean? You've negotiated that great executive employment agreement. You did everything right going in the door. How do these caps impact you? What's going to happen? Well, one obvious issue is that the caps may run contrary to contractual obligations that are owed you, right? Say, per your employment agreement, you have a base and then you have a bonus arrangement that's tied to some sort of metric that might get you above, you know, the cap in any given year. That gives rise to a breach of contract claim and may trigger a good reason termination, right? That's the way this is written, does not provide, at least not right now, a shield for the employer to not abide by its contractual obligations to you. What also may happen is that these caps may put a company's compensation plan in violation of their own rules, violating ERISA or triggering tax consequences. This is a mess both for employers and employees. I mean, there's no question that where we are is a problem. So one thing I wanted to highlight, again, 409A, as Brian said, this is a very problematic part of the Internal Revenue Code because it impacts executives. The penalties and the accelerated tax fall on the executives. So, for example, Suppose you attempted to negotiate with your employer a revised agreement that deferred the compensation that you should have been paid now to sometime after the restricted period, right? One would think you negotiate something, they'll pay you then with interest, whatever, that sounds reasonable. The problem is that runs afoul of 409A, and it could result in the immediate recognition of those deferred amounts as income to you, right? You get taxed on it now if you do that, and you get hit with penalties. Next slide, please. So it is generally believed that there will be guidance and relief from the government. I mean, these things are just too messy, too problematic. The problem is that guidance and relief is anticipated but not currently available. So affected executives need to take whatever steps they can now to protect themselves. And 3 points here. If you are still within a 1-year reference period, negotiate what is the best deal for you, whether it's higher compensation now so as to create a higher cap going forward, or less money now so as to avoid being capped for the next 12 months. You need to think that through and do your negotiations with your employers. Employers are expecting this. If a cap will create a breach of contract, take the necessary steps to protect that legal claim. In Massachusetts, we have a 6-year statute of limitations for a breach of contract. But as Brian pointed out, your contract may require you to take some additional steps, giving written notice, giving the employer an opportunity to cure. You may have to go through those steps to make sure that you don't lose that breach of contract claim. All right, suppose you have the right to terminate for good reason, and the failure to pay you what you're owed under the contract is one of those triggers. Consider whether or not to exercise that. Maybe you want to say, I'm triggered, raise my hand, I'll take my severance, even, there may be a haircut for it, thank you very much. Or you may want to negotiate for some extension of the exercise of the good reason period. So you may have to raise your hand and say, I have good reason, but your good reason trigger may say you have to raise your hand and be gone within 90 days. Maybe you negotiate that you don't actually have to leave, but you've still protected your rights. So those are all things to think about. David, turning it over to you.
Time for questions at the end, so I'll do my best to move quickly, but there are some important things that I think everybody should know as they contemplate potential exit, an involuntary exit in the time of COVID. As Nancy and Brian were talking about contract claims and people with executive employment agreements, one of the things you need to look to is your cause provision and whether the employer can cite a lack of funds as cause. Some contracts will say insolvency gives right to that type of an action. Some say financial distress. There's a number of different ways that employers will try and draft that provision to give them an out. But if you have an executive employment agreement with a cause provision that does not explicitly state financial distress, you are likely entitled to your severance pay, notwithstanding the company's financial distress if they're looking to move you out due to COVID. But putting aside the contract claims, I think one of the most important things that the people listening today need to hear as they think about whether or not their termination was an unlawful termination is that COVID does not bulletproof an employer from claims of unlawful discharge. And when we talk about unlawful discharge, what we're really asking is whether an employer has an unlawful motive for taking the action in question here, a layoff. In a vacuum, a lack of funds or a downsizing is a lawful reason to terminate employment. But in that context, what the courts have told us is the question focuses to why you. And so if the entire company remains, but you have been selected for layoff along with a few others, why wasn't somebody else selected? And if the reason that you were selected is unlawful, your claim can prevail. And so an employee can prove unlawful discharge through direct evidence or indirect circumstantial evidence. Some employers might say, look, COVID is hitting us hard, our business is struggling, and we're going to use this opportunity, this round of layoffs, to try and clear out some of the older employees and make way for new blood. Now, that would likely be considered direct evidence of an unlawful motive. Or maybe they will say that, it's time to trim and we can get rid of some of these squeaky wheels. People have been complaining about either failure to be, get all of their commissions or failure to have a safe work environment. Again, if an employer is so crass as to say that, you might have direct evidence, but more often than not, employers know enough about the law to avoid comments like that. And so instead, an employer is looking to circumstantial evidence, but circumstantial evidence of discrimination claims is still effective evidence. And circumstantial evidence is anything that would lead a reasonable person to infer an unlawful motive. And so I think what people often lose sight of is what you see, what you hear, what you observe, that is competent evidence. How else can you gather evidence? A couple of things to keep in mind. Many states in America have a personnel record statute that entitle people to gather information. Here in Massachusetts, an employer is obligated to provide to an employee within 5 days of a written request their personnel record, which is more than just the personnel file, not just your offer letter and your group benefit documents, but instead anything that identifies an employee to the extent it can or may be used to affect an employee's qualifications for employment, promotion, transfer, additional compensation, or disciplinary action. And requesting a personnel record is an excellent way to gather a better sense of the picture around your separation. The other thing is, to the extent that you have been let go in a group setting, when an employer terminates 2 or more employees, in order for them to obtain an effective release of age claims, they need to provide information about what's called the decisional unit. And so they would be required, in order to get an effective release, to talk to you about which groups of employees were covered for layoff, any eligibility factors they used for that layoff, the job titles and ages of the individuals, not only who were selected, but also who were not. And so all of this can help an individual gather the type of information they need to effectively assess whether they have a powerful circumstantial claim of unlawful termination. One of the things that we're seeing go into hyperdrive, frankly, as coronavirus and lockdowns take place, is the issue of company property versus personal property. Now, Brian spent some time talking about people's fiduciary duties and their obligations to the company. It's important to remember a couple of things. One, what's yours is still yours. People who have left those pictures on the wall at the office, people are making arrangements to get those things back in socially distant ways. But the flip side of that is that where you have company property, even if you've been using that laptop every day for everything for years, it is still the company's. And where people find themselves in really hot water is when they start taking unilateral action. They get that layoff notice and they get very scared that their bank statements are sitting on that laptop that they were supposed to be using only for work. The first, I think we have it on the slide, do not delete anything. Not because they're going to necessarily be entitled to see your bank statements, but because the old saying is that the cover-up is worse than the crime, right? If the employer sees that a swath of documents have been deleted from their computer, they are going to assume the worst. And you may find yourself defending allegations of breach of fiduciary duty, breach of confidentiality, or other property obligations you have under contract, or far more scarily, a claim for misappropriation of trade secrets, which under the Uniform Trade Secret Act that Massachusetts has adopted, and I think every state but New York has adopted, you can be on the hook for multiple damages and attorney's fees. And so there are ways, either on your own or with competent counsel, to choreograph the management of personal property versus company property. But unilateral action can make the situation much, much worse. one of the things that we are seeing come up a lot in COVID now is issues around leave rights and reasonable accommodation rights. Now, the first thing we should talk about is the new statute, the Families First Coronavirus Response Act. Now, this has two leave provisions. One speaks to sick leave, which an individual can access up to 2 full weeks of paid leave, 80 hours, for reasons including childcare, quarantine, COVID symptoms, either on your own or someone else's. And that can be taken on an intermittent basis, and which means you can take it for a day here or there, or take it for a few hours to the extent that that's applicable. The second leave benefit provided by the Families First Coronavirus Response Act is paid medical leave, or paid family leave, excuse me, whereby an employer is now obligated to pay up to 12 weeks of paid leave for an individual who is unable to work because their children no longer have effective childcare due to COVID. The care center is closed, schools have closed, the nanny is unable to get to you due to lockdown or due to illness of their own. There are caps on that type of pay. It caps at $10,000, and the first 2 weeks are to be fully paid, and each week thereafter is at 2/3. Beyond the new statute, there's an existing framework of laws that can provide some protection. And so the Americans with Disabilities Act requires an employer to provide a reasonable accommodation to allow an employee with a handicap to perform the essential functions of their job. And so if you have a condition that makes it unsafe for you to go out in pandemic times, this is far from clear at this time, but there might be a colorable argument that you have a physical or mental condition that substantially limits a major life activity, which is the statutory definition of a handicap. You may be entitled to an accommodation if you're a high-risk individual when it comes to coronavirus. The other thing is that while the Families First Coronavirus Response Act, before I move on, I should note, at least here in Massachusetts and in many other places, a leave of absence may be a reasonable accommodation. Now, how long that leave of absence needs to be, it's a very case-specific instance, and I wouldn't go out and ask for a leave of absence as a reasonable accommodation until we all have a vaccine, but it's something to keep in mind. Beyond that, you also have the Family Medical Leave Act, which provides for 12 weeks of unpaid leave for covered employees. One last thing before we move to the other slide that I did forget to mention, I know we only have 2 minutes left, but the Families First Coronavirus Response Act applies to private sector employers with 50 or more employees, but less than 500 employees. And so it's actually a relatively narrow band of employers in the private sector that are covered by this obligation. As you're thinking about leaving, just because the company is having financial troubles doesn't mean they don't have to pay you what you are owed. And so whether at a federal level under the Fair Labor Standards Act or in Massachusetts under the Wage Act, if you have earned your wages, they are obligated to pay it to you. And I know Brian spent some time talking about choreography and making sure that you get that bonus in the bank before you make a move. Legally, it's a really significant distinction because wages are protected by statutes that provide for attorney's fees and multiple damages. But if it's almost earned, you're dealing with a very different claim. And you may have an argument that if based on your past performance, you were right on the cusp of earning something before you were let go, you may be able to get some or all of that money. But you as a departing employee would much rather be looking at what is clearly an earned wage. And that's why Brian's note about choreography is so important. Similarly, as it speaks to equity or options or deferred compensation, I know when people lose their jobs, there's a lot of things going on and it's a hectic time, but looking through your equity documents to find out what exists, what persists, what your exercise windows are, and making those decisions in a timely way can really help protect you going forward. And then I think that takes us on the next slide to post-employment restrictions. I think we're run out of time to talk a lot about the new statute, but Brian did address the notion that what is reasonable is going to be the touchstone. And unfortunately, while the courts tell us that these employment restrictions are disfavored, the decisions tell us that they are enforced. And so just because what you have seems ridiculous on its face, do not assume it gets thrown out, because both the new Massachusetts statute and most states in America allow a judge to what's called red line the agreement, or blue line, I think they call it, where they literally are entitled in a judicial proceeding to modify the restriction to what would have been or what is now deemed reasonable. And so even if you have the broadest non-compete in the world, don't assume that because it's so excessively broad, it disappears. You will likely have a restriction at the end of the day. And I think with that, we're out of time, but I'd be happy to field any questions that, that people have.
Yeah, thanks, David. So we did just have a few questions come in. First, what changes are you seeing with how employers are handling severance benefits during COVID?
All right, so I'll field this question. So I guess just quickly, twofold. I really haven't seen any, as far as negotiating contractually owed contractual severance, I really haven't seen much difference. It certainly hasn't been well, it's a new ball game now, whereas, you know, executives used to get 12-month severance under their contracts. Now they're getting 6. I'm not seeing that. I mean, I think the negotiations around standard severance, what's market, what's done within an organization, that seems to be consistent, at least so far. That might change, right? Severance plans may become less generous over time, but what I have been seeing, and this was somewhat similar to what we saw back in 2008, 2009. It's more along the lines of what the company has done historically, what the precedent has been in the past, maybe outside contractually owed severance, whether it's the equities of the situation or otherwise. You know, there might be some precedent as to how companies have treated certain, certain levels of people on the way out the door, whether or not they were contractually entitled to it or not. And in that respect, I have seen a shift. And it's a little bit of, yeah, that was pre-COVID. We're now in COVID world now. And we saw a little bit of that we saw a lot of that back in 2008, 2009, when, we'd make an argument, look, the precedent for somebody at this level under these circumstances for leaving is X. And the response was, that was back in 2001. Now it's 2008. So I am seeing some of that in a COVID world. So.
Thanks, Brian. Next question, is being high risk for COVID a disability that entitles me to accommodations?
Sure, and I think I touched on this briefly, but with the big glaring neon light disclaimer that we don't know the answer to this, yes. Analytically, I think there's a strong argument that you have a right to an accommodation, because obviously it will depend on what puts you at high risk, and certain things that might put you at high risk might entitle you to other benefits. For example, at least here in Massachusetts, if you're at high risk because you're pregnant, not only do you have rights under the Americans with Disabilities Act and anti-disability discrimination statutes, you also have rights under the Pregnant Workers Fairness Act to certain accommodations. But if what's putting you at high risk is a physical or mental condition that substantially limits a major life activity, like going outside, then your employer may have an obligation to provide you a reasonable accommodation. And they, to be safe, should be engaging with you to find out what that reasonable accommodation looks like. This doesn't mean they need to do whatever you ask them to, but it does mean that there should be a dialogue taking place to figure out what can be done to allow you to perform the essential functions of your job with accommodation.
Thank you. So I think that's all the time we have for today. I'd encourage, if anyone has any additional questions, to follow up directly with Brian, Nancy, or David, whose contact information is on the screen. So thank you to Howard and Essex, and to our panelists today. And I hope everyone found it informative, and have a great rest of your day.
Thank you.
Thank you.
Thanks, everyone.